parties filing this initial petition were asked to produce an offer of proof that they are able to satisfy the deficiencies in the original petition. Specifically, the first two elements that are required as outlined in MCL 700.1208. The specifics of that are in that particular order. And today's the date time for that. May I have your names, please?
Michael McFarland, attorney, guardian ad litem for Dee Warner.
Good morning, Your Honor. Todd Flood on behalf, I'm the petitioner on behalf of Ms. Brown.
Good morning, Your Honor. I'm Larry Lee, by appearance on behalf of Dee Warner.
Thank you. And our Zoom participants?
Suzanne Wilhelm, GAL for Angelina Warner.
Good morning, Your Honor. John Polderman on behalf of the successor conservator Charles Bullock.
Good morning, Your Honor. Ariel Berger here on behalf of Dee Warner.
All right. Do we have any other family members that wish to be identified for the record?
I'm Greg Hardy, brother of Deanne Warner.
Thank you.
Rachel Bach, the daughter of Dee Warner.
Ms. Bach?
Amber Million, daughter of Dee Warner.
Amber Million?
Tim Bach, son of Dee Warner.
Thank you. One of the issues that came to the court's attention in reviewing the file today is that there still remained a proof of service issue indicating that several of the interested parties were never served a copy of this particular petition.
Sorry, there was other family members.
Oh, okay. Well, we'll get back to that. And so, Mr. Flood, if you want to address that.
Your Honor, if I may, just briefly, yes. We came late to the game, as you well know. We served a petition on everybody that we had the ability to do so. I think everyone to date has been served with the amended petition for which we filed this emergency motion on today. If that's not the case, I'm not aware of that.
So that was part of what was identified as a deficiency in the hearing that resulted in the order being issued on February 3rd. If the identified parties that had been overlooked wish to waive notice on that, then that's acceptable. Otherwise, that's going to be something that's going to prevent us from moving forward today.
I understand.
As I indicated at the last hearing.
Judge, as you well know, I think anyway, my papers that I submitted show that I came after the original order by like 2 weeks, not knowing what you had put on speaking through your orders, right? I didn't know what your orders were because I wasn't here. We found out the deficiencies immediately once we came to, aware of it. We notified the court, sent an email. I talked to Mr. Lieb or left Mr. Lieb a message. I've known Mr. Lieb for quite some time. Sent over to him a cure of the deficiencies, and it's my understanding that the only objection we have today was based on the amendment of the petition.
All right. Would you like to call any witnesses, namely your interested parties that were not served a copy of the original petition, to see if any of them would be interested in waiving notice?
Judge, if I may speak with Ariel for a brief moment to see if we want to cure that way. If you could give me a brief moment, Judge, for allowing me a quick break. It's great to have Ariel here to back me up on this. Anyway, Your Honor, we have the family members here that would waive the issue as it relates to receiving the petition and notification. It merits mention they have received the amended petition that we requested, but I can put them quickly up on the stand just to measure twice and cut once, so we can take their testimony for satisfaction of the record, if that's all right.
Any objections?
No.
None.
I don't object, Judge.
No objection.
Okay. Amber Million, daughter.
have a seat and talk right up to that microphone.
Morning.
Morning.
I think we might have met once on a Zoom call. Is that fair?
Yes.
Okay, haven't met since, right? Okay. Please tell this court, for the record, your name.
Amber Million.
And how are you related to deceased Dee Warner?
Objection, there's been no evidence whatsoever presented that Ms. Warner is deceased.
All right. How are you related to Miss Warner? Dee?
Okay, I'll allow you to rephrase. Go ahead. Thank you.
I'm her daughter.
Okay. And you're in this matter as an interested party. You know why we're here today. Is that fair to say?
Yes.
Okay. And you have had the opportunity, I think on one occasion, to receive a petition from a previous lawyer. Is that fair to say?
Yes.
And subsequent to that, I have come in. That's when we met over the Zoom. Fair?
Yes.
And you have received and talked about a waiver of, or I'm sorry, a new petition being filed with this court. Is that fair?
Objection, Your Honor, we're here on the original petition. The new petition has not been considered.
I understand, but she received it. Goes to weight, not admissibility.
Goes to whether or not she received the original petition, and she's already acknowledged she has.
And I'm going to have her
I'm
waive.
gonna overrule the objection. It's fine if she's been served with both or one or the other. If the issue is whether she has really any objection to us moving forward,
Thanks.
these issues.
I just, I don't want to come back and have to redo this for a second petition. So that's all I was doing. As an interested party in this matter, you waive having receipt of all petitions in this case from my party, my side.
Yes.
Okay, thank you. I have no other questions.
Okay, one moment. Do any other attorneys have any questions?
I have a question.
Mr. Lee?
Ms. Milligan, when did you receive a copy of the petition? At the time it was filed back in September of 2022?
I don't know the exact time.
Is it likely that, let me back up. Who is Raquel Bach?
My sister.
Okay, is it, you acknowledge that she's the original petitioner in this case?
Yes.
Okay. Did she at some point prior to today present you with a copy of the original petition?
Yes, I'm aware of it.
Thank you. No further questions.
Thank you. Anyone else have any questions for this witness?
No, thank you.
No, Your Honor. Thank you. From our Zoom attorneys?
Nothing, Your Honor.
Okay, we'll take that as a declined invitation from Ms. Wilhelm. You're welcome to, oh, there
None,
she
Your
is. Thank you. Yeah, thank you for your testimony. You may return to your seat.
Next, Your Honor, we're going to call Timothy Bach. Morning, sir.
Good morning.
Please tell this honorable court your name for the record.
Timothy J. Bach.
Mr. Bach, your relationship with Miss Dee Warner.
I'm her son.
We're here based on a petition that has been filed in this case in a matter of declaring your mother deceased. Do you waive the right to receive the petition, either the former or the current petition, as we sit here today?
Yes.
Thank you. I have another question.
Mr. Bach, you received a copy of the original petition in this case?
Yes.
When did you
Could you
receive?
step right up to our microphone? Thank you.
When, tell the court when you received that prior to today.
About 3 weeks ago.
You had an opportunity to ask questions about it?
Yes, and I'm well informed on the current.
Great. No, thank you. No further questions.
Okay, one moment. We have several attorneys here. Does anyone else have any questions?
No, Your Honor.
No, thank you.
No, Your Honor.
All right, thank you. You may return to your seat. Thank you for your testimony.
Mr. Zach Bach. Could you please tell this honorable court your name?
Zachary Bach.
Mr. Bach, how are you related to Ms. Dee Warner?
She is my mother.
You understand why we're here today?
Yes.
Okay. And you understand there has been petitions filed, one originally by a former lawyer and one by me. Do you understand that?
Yes.
You waive the right to receive those petitions, even though you have a right to see them, go through them, read them, ask questions. You waive that right, understanding why we're here today.
Yes.
Thank you. I have no other questions.
Mr. Bach, before today, you received a copy of the original petition, is that true?
Yes.
And when was that?
Many weeks ago.
Many weeks ago. You had an opportunity to ask the other attorneys questions about that petition?
Yes.
Nothing further, Judge.
Any other questions?
None, Your Honor.
None.
None, Your Honor.
None.
Your Honor, my client, Raquel Bach, she wasn't on any kind of notice. She did receive my petition, so I don't have to call her. I think I'm done with, I think, the questions at hand for this court to clean up the record. Unless you know of something I don't know as it relates to any other people.
No, it was just those particular individuals that gave testimony today, as I understand it.
Thank you.
Are there any other issues around this particular petition that any of the other attorneys want to raise before we get started?
Yes, Your Honor.
Mr. Lee?
Your Honor, petitioner Raquel Bach filed her petition in September 16, 2022. It was published to the community pursuant to statute and this court's order. 6 months have gone by.
So I just went preliminaries, not necessarily into like the actual reason we're here today. So like service or any other preliminaries?
Well, I think, Your Honor, 2 days ago, the petitioner in their emergency motion to amend the petition admitted that the original petition was not only deficient, but was term.
Well, why don't we let him present on his motion first, and then you'll be able to do your response.
Well, because I think it's preliminary, Judge. I think that we shouldn't even be here. The court issued an order February 3rd ordering Ms.
It's really
Gaines.
my understanding you file an objection, but the objection usually typically comes after the initial motion. So please have a seat, and we'll allow Mr. Flood to make his motion, and then I'm happy to listen to your objections.
But Your Honor, with all due respect to the February 3rd order that this court issued, they have not met their burden by claiming that.
Mr. Lee, please have a seat. Thank you. The reason that I am willing to engage in a conversation about this emergency motion is because the question still remains that there would be an offer of proof necessary. I've read your motion. Even if I allow you to amend, the same question will present, which is, what is the accident or disaster that has occurred in this case? Or what, is there any evidence whatsoever of an accident or disaster that would allow this court to move forward on a petition under this statute? So the question is still the same, whether it's couched in terms of the order issued February 3rd, or as it relates to a response to this emergency motion that's filed. The question is the same. Mr. Flynn.
Thank you, Judge. Just to be candid, there isn't under this particular statute that was enumerated by the previous council a catastrophe/accident that gives rise for a declaration of death. That's why I made the amendment under the specific statute paragraph that gives prima facie evidence of death based on the following evidence, circumstantial, but clear and convincing, that she has been gone, that there was a missing persons report immediately, that's a government document made by the sheriff's department. And as an order of proof, 1101 and 103 under the rules of evidence, I can use anything to satisfy the court to establish that fundamental, I guess, prerequisites to get to a jury trial. So I'm scratching and taking away the fact that there was an improper filing for a petition. We are now moving under the correct statute that talks about death based on circumstantial evidence under clause C of the statute, which I laid forth in my papers.
Circumstantial evidence, death by accident or catastrophe, right?
No,
Okay,
no.
so
So that would be inaccurate. If you go to the motion, prior counsel, Ms. Gaines, filed it under death of accident or disaster. Under basically it was a approved a CAO form, which was an improper form. So it had to be properly done, which we did. We state on page 5 that the petition was deficient and that it failed to address the first two elements of the statute 1D. So we amend under the court rule 2.118, also under subparagraph A2 and C as well, where we can amend all the way through jury trial. We rely on 700.1208 paragraph 2, which states an individual whose death is not otherwise established under this section or section 1207, who is absent for a continuous period of 5 years during which he or she has not been heard from, or whose absence is not satisfactorily explained after diligent search or inquiry, is presumed dead. However, the individual's death is presumed to have occurred at the end of the period unless there is sufficient evidence to determine that death occurred earlier. That is, I label with emphasis for that particular paragraph in the declaration of death. Again, unless there is sufficient evidence to determine that death occurred earlier. Dee Warner was not the victim of a disaster or a catastrophe of that sort. We assert that there's convincing evidence, obviously circumstantial, to show under the proper paragraph and heading that she is deceased, and we can show that by clear and convincing evidence of all of the things, from the Secret Service giving us the whereabouts of travel, both domestic and international, not there. The banking records, no transactions taken. Family members, absent. She was the primary caregiver of her minor child. Testimony will come that only over death would she leave that child. Phone records. We also have, as this court well knows, I think I've spent in this court probably, I don't know, $300 and taking on subpoenas from everywhere you could possibly imagine. Her doctors, the morgue, the hospitals, all vacant, not with her. So it's not, I think, candidly, I can prove this beyond a reasonable doubt. However, I only have to establish it by clear and convincing evidence. That being said, we have a litany of witnesses that will give both direct and circumstantial evidence of her death, that being missing, and prima facie evidence to show. We have 2 Michigan State troopers that are going to come up here and testify that have been working on this case for the year. I shouldn't say that. They took it over from the sheriff's department. So I'll say for about 8 months. And the troopers have diligently gone through everything they need to go through to establish death for their own investigation. They will come and opine and testify that based on their investigation, there is no other conclusion one could come to other than that she's dead. So I can put witnesses up. I got the family here. They will establish, if you want, under the court rule and rules of evidence 1101 and 103, you can use anything you want to make that determination. It's a preliminary question of fact. And based on a preliminary question of fact, you can use a polygraph if you want. You can use anything if you want in that evidentiary hearing. So I can, Your Honor, put the brother, the siblings, the offspring. I have Mr. Mark Myers from my office, retired police chief out of Dearborn Heights, who's been working with the Michigan State Police here and his diligence for what she has done. And I'm prepared to do that. The question becomes, Your Honor, there is no way I can establish that there was a plane crash, that there was a train accident, that there was a boating accident, wherein we couldn't identify the body. I can only establish, as the statute allows me to do, that for which she, Ms. Dee Warner, is dead by prima facie evidence and circumstantial evidence, both government evidence and circumstantial evidence. So that's what we're here to do today. And I understand Mr. Lee objected, but Your Honor, you've tried many criminal trials, civil trials, and as the court well knows, the facts lead the day. And based on that, we can amend informations all the way up until closing arguments in criminal cases. And you can do so in civil cases as well, under 2.118C. The facts dictate the day. That's why we asked to cure the petition. That's why we're here today. If the court doesn't allow me to cure the petition on this notice, we'd have to start all over because we can't impanel a jury. I want to do it once right. So that's why we're here, for me anyway, and to ask the court's permission with your authority to move forward by proof that Ms. Dee Warner is dead based on the evidence and circumstantial evidence under the proper paragraph and statute. So that being said, I leave it to the court of how you want me to proceed, because those are the two things you really wanted. I think what you wanted, if I got it right, is you wanted it right. You didn't want it wrong, and it didn't make sense based on the previous petition. So that's why I'm here.
So are you effectively withdrawing the original petition?
I'm amending it. I'm not withdrawing, I'm amending it. If I have,
Are you then abandoning that particular aspect that was alleged in the original
right,
petition?
right, and to the previous attorney's credit, when you read her papers, she references the proper paragraph and footnotes in a couple paragraphs. But I think what threw, and I haven't talked to her since, was the form that was given by the court's probate department of the approved form, which didn't have all the nuances of what it should have been brought under, if that makes sense. So.
Okay, response? I'm going to give everybody an opportunity to respond. So, I know Mr. Lee is very enthusiastic about responding and objecting, so I look forward to your arguments.
Thank you, Your Honor. I have known Mr. Flood a long time, and this is not personal to Mr. Flood. With all due respect to you, sir. He inherited a problem. And the problem began back in September of 2022, when another attorney representing Raquel Bach, and now acknowledged by all the siblings, filed a defective petition. It was defective then, it's defective now, it's been admitted to be defective by Mr. Flood, and there's no way to correct it. We've been to a hearing on January 30th, in which this court admonished the other attorney and Ms. Bach and issued an order on February 3rd that set out specific criteria that were necessary in order to proceed with a jury trial on March 16th. Admittedly, Mr. Flood says today, they can't meet their burden. And so this court has no choice but to dismiss that petition with prejudice. If Mr. Flood would like to file another petition and start all over, that's what the law requires. He can cite whatever court rule he wants about amending this, amending. That's not what the statute allows. The statute says you filed a petition, you then have to serve it. It has to be published, like the petition that was filed back last September. And frankly, I think it would be an abuse of discretion for this court to allow Mr. Flood 2 days before the hearing today to file an emergency motion to essentially change their theory of the case after 6 months, change their theory of the case, and now proceed on a different theory of the case that is really nothing more than a catch-all in the statute. Now, Mr. Flood was ordered, like we were, to produce a witness list. And the witness list that he produced had 50-some names on it. There were no addresses, there were no phone numbers, there was no opportunity for any of the other parties, myself, Ms. Wilhelm, Mr. McFarland, to contact any of the potential witnesses. They filed an exhibit list that lists dozens of documents that we've had zero access to. And while Mr. Flood is a very competent attorney, he still can't climb off the burden that this court put on him. This court has no choice but to dismiss the original petition. And if the family would like to file a new petition, that would be, I guess, their right. Otherwise, the statute requires that they wait 5 years for the presumptive declaration of death. Now, I've been doing this almost 30 years. And in 30 years, I have never, until 2 days ago, been presented, after 6 months of a litigation, an emergency motion to amend a theory of the case, which essentially is like filing a new complaint and saying, you know, everything we said for 6 months in all of the documents and all of the hearings, you know what, doesn't mean anything. And now all of a sudden, we've got a new theory of the case. It's going to be a catch-all. We're going to present this person and that person. That, you know what? All along, we have pursued this case, and I have defended Mr. Warner on the basis that the petition was that the family believed that his wife was a victim of an accident or natural disaster. Well, now we find out that that's not true. Our belief is, and our theory of the case is, Ms. Warner chose to leave the community on her own on April the 25th, 2025. Excuse me, 2021. We believe that since 2014, we've got evidence to prove too. We believe since 2014, she, along with her son, Zach Bach, one of the folks here, and another associate, Stephanie Volke, assisted Ms. Warner in misappropriating hundreds of thousands of dollars from Mr. Warner and their family businesses. That she had essentially bled the companies to the point at which there's an over $500,000 tax debt to the IRS. And that with overwhelming issues coming down on her, she chose to leave the community. We don't believe that she's deceased at all. We believe that she chose to leave and at some point will be found. We believe that she will at some point come back. Dee Warner, Your Honor, has been under an enormous amount of pressure for almost 2 years. To date, there has been not one scintilla of evidence produced in any capacity that would suggest that he had anything to do with Miss Warner, if you want to call it disappearance. you wanna
Your Honor, I'm
call
going to object. We're not here to determine if Mr. Warner had anything to do with Mrs. Warner's disappearance or possible death. We're here only to determine if she is dead.
I concur in the objection, Your Honor.
No position.
Any position on the objection?
No, Your Honor.
No, Your Honor.
I find that a valid objection. I will sustain it and ask you to just refocus.
Thank you, Your Honor. We believe Miss Warner is not deceased at all. In fact, we believe she's living, maybe even in this community. At the time,
Judge, I think you're just ruled on an objection based on what
No.
Mr. Lieb is presenting. It's a question whether or not of the amendment to the petition, not necessarily the proofs. The preliminary question of fact, we can get into that, but we're here about the amended petition at the time, at this hearing, was what I understood.
And I think you have addressed, in large part at least, your response to the emergency motion and your objections to that. Is there anything else you want to say?
that's fine, Judge. We actually would ask for sanctions too. We believe that sanctions are appropriate in this case. At the time this case was filed back in September of 2022, the attorneys at the time knew that they could never prove Warner was a victim of an accident or a natural disaster. It's been 6 months. The court ordered on February 3rd to produce evidence of that. Today, they've admitted that they can't because their petition was defective and that they can't. We've been here at least 3 times on this case, and we filed various pleadings and responses. And, you know, I'm not speaking for Mr. McFarland, but I know that the county's time is important too. And frankly, this is a sanctionable thing. We would ask that the court dismiss the petition with prejudice and deny Mr. Ford's motion to amend the petition.
Ms. Berger?
Yes, thank you, Judge. Briefly, I would just like to point out that the motion to amend that was filed wasn't a motion to dismiss and replace, over to change the items that were listed in it. And if we all look at the original pleading that was filed, even the SCAO form does list MCL 700.1208 on the bottom of the form. So although the form language on number 5 states that the facts and circumstances concerning the accident or disaster are as follows, it says see attached. And that attachment also clearly lists the statute in which we are proceeding under today, which is MCL 700.1208. It's listed on the form pleading on the SCO form, it's listed in that motion, and it's expounded upon on the amended complaint or the amended petition that has been filed. And all due respect to Mr. Lieb, it's kind of how things work. If we show up that we found other evidence today, that's what the court told us to do. And so that's what the petitioners did. They've included ample evidence in their amendment, their motion to amend, that states that there is clear and convincing evidence, or that they think that they can find clear and convincing evidence, or prove that to a jury that Ms. Warner is deceased. And that's what we're here for today. We're here to make sure we have all of the proper witness and exhibit lists exchanged. We're here to make sure that we have an offer of proof that can properly proceed before a jury. And because the amended motion isn't a motion to replace, it wasn't a dismissal or anything like that, and because the original pleading lists the correct statute on it, on the SCAO form, and in the body of the attachment where the original attorney puts the attached.
There's a copy for the court if she needs it.
Do you need a copy, Your Honor?
No, I have a copy. I'm looking at it now.
Perfect.
So while we're at an interruption impasse, 1208 specifically regards the procedure to establish death of accident or disaster victim. My understanding of the amendment is that Mr. Flood would like to redirect the court to 700.1207 subsection D, which is, as Mr. Lee frankly adequately put it, is sort of a catch-all. So that would be very distinctly different from the statutes that were indicated on the petition, original petition, which is 700.1207 E, F, and then of course MCL 700.1208. There's no specific reference to subsection D in the scale form.
Well, Your Honor,
So if I misunderstand that, please correct.
I believe what we're asking for today is that we proceed under the 700.12082, which states at the end of that paragraph that unless that the individual's death is presumed to have occurred at the end of those above periods, the 5 years, the accident, all of those things, unless there's sufficient evidence to determine that death has occurred earlier. And that's what we're asking to proceed under.
12082.
It's,
Well, both.
Yeah.
So it states 12082 states that unless it's established under 1207,
Or she's
Or-
gone for 5 years.
or not and at the end of that, it says that if either of those things happened, the 1207 factors or the 12082 factors, unless there is sufficient evidence to determine that death occurred earlier. And that's what we're asking for. That's listed in the original pleadings. That's listed in our current pleadings, rather, Mr. Flood's current pleadings. And that's what we're asking to proceed under.
So are you telling me that you want me to, I just want to make sure I understand this, because 1208 refers to 1207.
Yeah.
You're telling me that you want me to go into 1207 based on 1208's reference to it?
Both ways, Your Honor. So the SEO form lists 1207 E and F and 1208. 1208 lists unless the things that happened in 1207 happened, or these things. If either of those things happen, great, we presume death, unless we can provide evidence to determine that death has occurred earlier. And that burden is only clear and convincing. And I think that with what has been presented to the court, we have established that there's enough to present it to a jury. That's all. Thank you.
Mr. Brown? Before you do that, I just want to clarify with you, Mr. Flood,
yes,
which section are you asking me to look at? Is it 1207D or something else?
no, it's, I have the statute here if you want it, Your Honor, it's D, it's, in the absence,
What's the specific statute?
700.1207 D,
Thank you. That's what I wanted to clear.
right? And just for reference, Your Honor, that was labeled in the original petition, as far as the briefing goes, so it's not a surprise, not a,
Thank you.
thanks.
Well, Your Honor, as guardian ad litem for Dee Warner, I'm here to express what I believe is in her best interest. I think one way or the other, we're going to get to the request under the amended petition, whether it's amended or whether it's declined, and there's another petition filed. I think we're still going to get to that point where we decide the statute that Mr. Flood described. I think, though, all the attorneys were under the impression, though, we were here to see evidence of death or a natural disaster, and that was not provided. So I think the jury list and the witness exhibit list, we're all under the impression that that was to represent that. And now we have something else. Appears to me that it's going to need to, number one, be discovery. As we're going to need to have an amended jury list with actually list who the witnesses are, contact information so we can reach out to them. In addition, I think really amended petition is the cleanest way to do that, but I'm also thoughtful of would Dee Warner want the family to go through added expenses to get to the same point, which I think we're going to get anyway. So I think that my position would be if the court allows an amendment that we reschedule the jury, that we have a witness list that list names, addresses, that the witness list is tailored to the amended motion, which I don't think it was, because there is an amended motion. And I appreciate Mr. Flood saying that there was complications, or perhaps it was not clearly stated under the right section. Now I'm hearing it appears as though it's another complete section. I think probably the cleanest way is actually to file a new petition. But either way, we're going to get there. As far as sanctions, I will let the court determine Mr. Leaf's portion is. I think the sanctions will come out of the children. I don't know that that's in Dee Warner's best interest, Your Honor. I don't think that she would want that to happen. But I do think there is a valid point being made here, and that the statute may apply. So also, I think advancement of justice, pushing this off to another day, which we're eventually going to get, is not necessarily judicial economy or efficiency. But I do think that the scheduled jury needs to be rescheduled, and that there should be time for discovery, and that the witness list needs to be appropriate with identifying information. Thank you.
Okay. Let's go to Mr. Holderman.
No position, Your Honor. I don't have any comment.
Ms. Wilhelm.
Yes, Your Honor. Thank you. I agree with Mr. McFarland, and representing Angelina Warner, and what I think would be in her best interest, what would be in her best interest. She's only 10 years old, so she doesn't really need to, she doesn't know much about this, and she doesn't really need to be going through this longer and longer and longer. So I agree with Mr. McFarland that it does look that there is a valid point being made that there is an avenue for establishing death other than through accident or disaster through 1207D. I do think that the appropriate court rule for amending in this case, though, would be Michigan MCR 5.118. And in 5.118, if I'm correct, it does say that you can amend by following the proper notice provisions. The notice that has been published in this case specifically states disaster or accident. And I would think that given time, we would need time to interview 52, I think, witnesses, and to go through all kinds of evidence. We need time to reschedule. I don't know how many days that hearing will take. And I do think that there is injustice to amending in 2 days and then within 9 days of the scheduled jury trial. There's
Okay,
just too many
that broke
witnesses.
up.
We don't.
Hang on, Ms. Wilhelm. It broke up just a little bit. Can you back up I think you were talking about something about days, 2 days or 9 days. So if you could back up.
Yes. Just that we don't have time in that 9 days to get the addresses. We might be able to get the addresses, but to start to go through those witnesses, to interview those witnesses, to prepare and be ready. I just agree with Mr. McFarland. We definitely need more time. I do think that judicial economy can play and should play a part here. If we're going to address the issue, we should just get to it as soon as we can. But I do think that we do have to go through I believe that the notice provisions of the statute, the 4 months, the consecutive publications, I think that this is a significant change. And I do think that the notice should provide for that. Thank you, Your Honor, but that's all.
Thank you. Would you like to respond?
Just briefly, thank you, Judge.
Your Honor, I just want to bring to the court's attention a few things. As I noted before in to the previous lawyer's credit, although there's some issues with regards to the petition, it states clearly in the background portion of the case, a certified or authentic copy of a record or report of a governmental agency, domestic or foreign, that individual is missing, detained, dead, or alive, is prima facie evidence of the individual's status and of the dates, circumstances in place disclosed by record or report. She posts that. She then cites the proper portion of the statute. Then she says, in the absence of prima facie evidence of death, under subdivision B or C, the fact of death may be established by clear and convincing evidence, including circumstantial evidence. To anyone that claims surprise at this hour, obviously didn't read that portion of the brief, and obviously didn't read the posting, because that's the posting, that's the notice, and that's what's given. Then you ask yourself the second question: what was it that was done in discovery to this date by anybody? Zero, except for what we brought in. So the fact that we sent out subpoenas, I haven't seen one subpoena in the court file, unless I'm missing something, that has been submitted by anybody other than us. So the fact that discovery hasn't been done by others shouldn't fall on my client's behalf. We've been working diligently for the past 33 days making this happen. Nothing prior. So posting was proper. Posting as far as what the claim was and how to establish. The fact that the statute is clear, there's no surprise. And if this court is inclined, and I am a conservative thought person on this philosophy, Your Honor, I always like to measure twice and cut once. I don't want to screw it up and have something come back. I want to do it right the first time. If it's a prophylactic measure to make it so that you believe or think in just that there is a delay in this jury trial, I'm asking you, pleading with you, just because of every court in our state and the Midwest right now is jamming everybody with trials, as you well know, because of the COVID. Schedules are insanely tough and tight, that we don't put this off. One, I'd ask that we be able to go through because no one did any due diligence otherwise. Or two, if you are inclined to do something with the request to move the trial, that we do it post haste. And I would be more than happy, Your Honor, to parade in the state troopers and the witnesses in front of the court and to lay out the prima facie evidence. You can take just one document today. You could take a sheriff's document that everyone received. We all got it. It's prima facie evidence that Dee Warner's missing. Even though it would be hearsay in a jury trial, it's not hearsay for this court could use it for that preliminary fact in question. So I think we have enough today to establish it if you wanted to go forth and not waste any time. If you are inclined, I ask that you please put us on as fastest track as possible.
Questions? How do you respond to the fact that the publication specifically indicates that a hearing will be held on a petition to establish death of accident or disaster victim?
We have to turn the next page, because in the publications also it's that of a person that is missing or gone, which then can be used and presumed to be dead, not necessarily by accident or catastrophe.
I'm not talking about the motion itself. I'm talking about the affidavit of publication that specifically indicates only a hearing on a petition to establish death of accident or disaster victim. That's what the publication says, according to the one that was filed January 25th, 2023.
So let's think about it from a rational, reasonable standpoint. What is it saying? Person's dead, gone, missing, right? Regardless if it was by accident or by, the catastrophe type of situation, the end is the same. Now you're just asking, right, by what means or where. Here, we're just asking, just like you would do in another matter, is yes, we still get to use the same statute. We're just moving up the letter to letter C that says the presumption of death by clear and convincing evidence. So it's the same thing. It's the same thing. I don't have a boat or a train. I'm not going to show that. But the requirement by the statute of publication is giving notice of one thing when you look at the history of the statute, and that of death. Look at the intent of the statute. It is of that person dead. So I'm doing the same thing. I'm saying by the spirit or by the what the statute implies is that Dee Warner's dead. And I gave notice to the world. Do I have creditors? Do I have anyone that came to us? That's what it's there for. When you need that, you obviously in probate, when you have to publish, you're publishing for a reason. So we did the same thing. Now the question becomes, if the black letter of the statute carries the day that you need me to republish death under a particular section, I think it's duplicative and goes against what the intent of the statute was for. But again, I don't want to come back. I want to do it right the first time. So that's my answer to your question. I hope it balloons some out there.
My next question is, and I just want to say, we do have clearly a conservatorship that concerns Ms. Warner.
Yes.
It's pretty clear she has disappeared. There's been a judicial ruling on that,
Right.
that she has disappeared. There is a specific statute that acknowledges death as a result of a continuous disappearance for a period of 5 years, as you know.
Right.
How do you intend to show not just disappearance, but also clear and convincing evidence, including consideration of circumstantial evidence, that there's been a death on top of a disappearance?
Through the facts and evidence in the case, if you want me to go into that, I can.
Briefly, please.
Yeah, sure. So besides having law enforcement involved and presumed of a potential homicide / death, they have gone through what we would normally go through in a missing body case for a prosecution. In a missing body case in a prosecution, when the court asks, what do you have, as it relates to that, you go through, you checked all the morgues, yes. You checked all the hospitals, yes. You checked the credit reports, yes. You checked social media, yes. You check everything that is a normal habit. And the circumstantial evidence that lands on those things, from your doctor appointments, your medications, you're not renewing your prescriptions, you're not attending the things you normally attend to for comorbidities, you're not doing the normal habitual things that you would do in the ordinary course of life, nor is it discovered anywhere else on the planet Earth that that's being done for Dee Warner. She's not on the Bahamas having a cocktail. We have no face recognition, no international transportation one way or the other by boat or by plane. We have no domestic transportation by face recognition or by any kind of train, boat, or plane. So when you line all of those things up and you say, hear from the family, what's her normal, ordinary course of habitual status, and you show the opposite of those things, you know as well as I do, Judge, clear and convincing evidence of circumstantial evidence, usually it paints a better Picasso than the eyewitness half the time. So the fact that I would have and can establish the Picasso through the circumstantial evidence, the things I just mentioned, I can prove she's dead.
Are there any other cases or authority in this area that you discovered in your research preparing for your motion?
So I talked to several prosecutors and chief judge in Wayne County to go through this. My partner in crime, Kevin Samowski, in my office was the homicide, chief of homicide. He did prosecute a missing body case out of Wayne County prosecutor's office in the homicide division. He went through the same steps through the probate division of a declaration of death. I talked to Karen Hansen and APA up in Genesee County, and also the prosecutor, the elected official in Genesee County about their no body death homicide case, and all of the things that you asked for, rightfully so, with the jury instructions. We mirrored those jury instructions for establishing clear and convincing evidence based on those two cases out of Genesee and out of Wayne County. There is a case, it's an old one, that is a relic, and I think I cited it in my brief, but I believe it took place in 1938 or 1958, that established death by a missing body under the clear and convincing statute. So I would be more than happy to supplement any briefs, and there is a law review article. I think I mentioned it to Mr. Lee, I'm not sure, but that dealt with this issue that I could supplement to the court as well. And Mr. Lee, that's all I have right now. Do you need any more from me?
I don't have any questions at this moment.
I'm always available.
I'm sure you want to respond, Mr. Lee.
I would, Your Honor. With all due respect to Mr. Flood's ability and all the people that he knows, we live in the world of DNA evidence. We live in the world of scientific evidence. We live in the world of having special technologies to pursue evidence. I don't want to get into the investigation, but the FBI, the state police, the sheriff's department have all investigated this case since day one. They've come up with nothing. There's been zero evidence produced. We turned over Mr. Warner's Apple Watch.
You're not going to object again.
Now I'm responding.
Well, the issues are whether or not the petition should be able to be amended, and if there's authority offered to allow that. And many of the questions that I asked Mr. Flood are really the opportunity for any kind of response, not necessarily the facts.
I understand, John, and Judge, and with all due respect to Mr. Flood's ability and the people that he knows, there's been no evidence presented that she's deceased. With all due respect again to
Can I
him.
finish my objection?
Yeah, sorry.
Thank you. I believe we're here today to decide if there's enough evidence, again, to decide if she's deceased, not if there's enough evidence for it to be prosecuted. What Mr. Lee was saying is that all these investigations have happened and no one has charged anyone. Great. We don't know what evidence they have. They're not knocking on my door giving it to me. They're not knocking on his door giving it to him. We're only talking about evidence that we can show in this case, not what the state police can show.
With all due respect to Ms. Berger, I was just responding to Mr. Flood and his comments. And if I might just finish, I'll just close with this.
All right, I'm going to overrule the objection in a limited sense because we did have a conversation brief, albeit about prosecution in similar cases. Although I will say that obviously this is not a criminal courtroom.
No.
So it's a limited guidance at best. So,
You know, it is not clear and convincing evidence that someone is deceased because they failed to show up for a nail appointment or a spa appointment or a healthcare appointment. Plenty of people choose to leave their communities and live very freely without going on the internet, without having to pay with credit cards today. They can certainly pay cash. At the time that this happened, it was during COVID. People wore masks. I mean, there's plenty of opportunities for Ms. Warner to have left the community just to say that she didn't show up for a spa appointment means she's deceased is just preposterous and ridiculous. Again, we would ask the court to follow its February 3rd order, dismiss the petition because there's been an admission that it was defective. We believe that the court should, if the court is inclined to, allow Mr. Flood to file a new petition, and we'll debate whether or not that new petition is the right one or not. I agree wholeheartedly with both Mr. McFarland and Ms. Wilhelm that notice has to be provided to the community. There's a reason why notice is provided to the community. Mr. Flood is essentially changing his theory of the case and providing, he can dance around the statute all he wants, but the fact of the matter is we all sit here, he's changing his theory of the case. And by changing the theory of the case, you have to republish that to the community so that they're aware of what's happening here and have an opportunity to show up and be heard. And that's our American way. And I agree wholeheartedly with Mr. McFarland that the laundry list of witnesses has to be discovered. There needs to be time to go through and interview them and find out what their potential testimony is going to be. And but we're not here to delay things, but we think, as Mr. Flood said, things should be done the right way. And if they're going to be done the right way, this needs to be a new petition with a new set of dates. And I'm quite certain we'll be back here at some other point in the future, but let's do it the right way, Judge. Thank you.
All right, does anybody else have anything else?
Yes, sorry.
I do have to.
I'll be fast. I just have a couple of points, Your Honor, about some of the issues that the other attorneys have brought before the court. As far as the issue of the witness list, that was ordered the last time we were here in court under the old petition. There's no way that anyone can show or understand or even debate if those witnesses would have been produced under the old petition or the new petition. You ordered the original filer to produce more evidence and for everyone to file witness and exhibit lists. If we were still under that old petition and this witness list came before us, it still could have had those same people on it and there's no way for anyone to tell. So that basic fact that there's too many people now for us to run discovery on should have been discovered at the last hearing when we asked for a period for discovery. As far as notice is concerned, under the specific language that you asked Mr. Flood about, I'm under the impression, which is in my brief that I filed back in January, that notice was accidentally met in relation to the original publication period. Because of that, because of the definitions of the newspaper in our statute, and because of the specific language listing the date and time of today's hearing in several news sources in print and in media, I think that the issue of notice, whether or not if it's an accident or not, those specific news outlets that are technically defined as a newspaper by the statute still cover the issue of notice. All of those news outlets say to determine if she's deceased. That's it. Not if it was an accident, not if she, whatever, just if she's deceased. In addition, even if we were under the old petition today, the same evidence was also ordered to be produced by today. So even if we don't have this amendment, even if we still have the old petition, Your Honor still ordered offers of proof, and that's exactly what was given. Even if we take out the new petition and the language that's in it, the exhibits which were attached to that and to the trial packet that were filed by Mr. Flood cure all of those issues that you had asked to be cured. And I'm under the impression that theories can change. Theories about a case change all the time. Sometimes they change when we're sitting here in the chair. As long as that theory is still within the bounds of the original law in which you're asking the court to make a decision on, that's kind of the name of the game. Thank you.
The biggest hurdle that I see in this case moving forward would indeed be the notice. We don't have any affidavits of publication from any of these other news media sources or anything like that. The purpose of legal notification, the publication, is to advise the public and or perhaps Ms. Warner out there what is going on. And from reading that notification, you would not know that we're covering the new issues brought forward today. So at a minimum, I think there has to be to avoid an appellate issue, there really does need to be a new publication with the very specifics of what's included under the amended petition with some clarification. You wouldn't have filed the amendment if you didn't think there was some need for clarification for the court. If it's enough for the court, I'm sure the general public's not going to know that. So I think they need, as far as transparency, to know exactly what's going on in the same manner. And in the event Ms. Warner is out there, that, and I'm not saying that she is, but that's a presumption right now, because the court's not made that ruling, that she needs to know if she is out there what it says, as does the public. So to comply with the publication, we have no affidavits from other sources. I quite clearly think the language is the natural disaster, not the other, but valid point that I think that's being made. So I think at a minimum, we need a new publication here.
Mr. Holderman, Ms. Wilhelm.
I don't have
Your
any
Honor.
comment, Your Honor.
Sorry, John. No, Your Honor, no further comment.
Do you want the last word, Mr. Fly? That's your petition, your motion today.
I think you've heard enough from me anyway. Thank you.
All right, thank you. I'm going to take all of this under advisement. It's also 11:55, so at this point, we're going to take a break for lunch. And I will be happy to give you my ruling on this after lunch.
Claim. And it was after breaking for lunch, Judge Sala issued her opinion. No jury trial will be held, next week at least. The trial will be held June 20th and 21st, with a new pretrial to take place May 12th.